for the purposes of Section 35(3)(n) of the Constitution, which guarantees the accused persons the benefit of the least severe of the prescribed punishments if the prescribed punishment for the offence has been changed between the time that the offence was committed and the time of sentencing. Using the earliest date in connection with this offence or these offences for determining the applicable parole regime and the period of parole non-eligibility in the case of continuing in multiple offences will ensure that the amended Act is in line with the constitutional rights guarantees in Section 35(3)(n). It will ensure that offenders benefit from the least severe parole conditions if there has been a change between the time of commission of the initial illegal act in the case of continuing crimes or the earliest illegal act in the case of multiple offences and the time of sentencing. This concludes the Helen Suzman Foundation submissions. I would like to thank the committee for your time and attention.
Thank you very much, Ma'am. I would now open this time to members to ask questions and make comments. Before I do that, I would like to also recognize the presence of our Deputy Minister, Phathekile Holomisa, who is leading the contingent from the Department of Correctional Services.
Thank you very much, Chairperson. I am here the delegation of the department. I was supposed to be at a cabinet committee meeting, but the meeting was finished quite early. So I thought I should come and eavesdrop to what is happening in the committee to prepare myself for further deliberations.
No, thank you very much, DM. Thank you very much. We hope that you would find this engagement fruitful. I note the hand of Honorable Nivot Drachen.
Thank you very much, Chair, and good morning to everybody. And good morning to the Helen Suzman Foundation. Thank you for your presentation. I just have one simple question. I would like to ask, what is the reason behind using the earliest date of, the earliest date instead of the last illegal act committed? If you could just clarify that, thank you.
Thank you very much, Honorable Nivot Drachen. Any other member who has a question or wants to make a comment? I take it that members are satisfied with the presentation made. Can Honorable Nivot Drachen's question be answered by the Foundation?
Thank you for that question. I think the reason that using the earliest date is particularly important is because it complies with the constitutional requirements that are implicated in this case. So if there's a significant change in the parole conditions between the time that the initial illegal act is carried out or the earliest crime is carried out, the accused person or the offender should have the benefit of the least severe of those possible parole conditions. It would be inconsistent with our constitutional scheme, which guarantees a right to least severe of prescribed punishments if there's a change in punishment over time, if we were to use a later date as the relevant or operative date for determining the applicable parole regime. And this would obviously open up an amendment bill to a possible constitutional challenge requiring future or further amendment.
Okay.
Thank you.
Thank you very much. I see that there are no other members who want to interact with the presentation. Can I now get the preliminary views from the department?
Good morning, Honorable Chair and attendees. It's Jacques van Wyk from Correctional Services, Legal Services. If I may be provided the opportunity to provide a response to the issue raised by the Helen Foundation Helen Suzman Foundation. Thank you, Mr. Chair. Can I proceed?
Yes, you can proceed, sir.
Thank you, sir. We thank the Helen Foundation, the Helen Suzman Foundation for their submission and their input with regard to the bill. It has to be stated, however, from the onset that the issue of using the earliest date for continuing and multiple offences was not in dispute in the matter itself. Secondly, it has always been applied in correctional services. Remember, with regards to PARTLA, it did not change the fact that how it was dealt with previously before the PARTLA judgment with regards to continuing and multiple offences committed. It has always been that one was using the earliest date because of the different parole regimes and parole policies applicable. One also refers to the Van Wyk judgment and the Van Vuuren judgment and policies of parole that changed specifically during 93-94. For example, in the old parole policy with regards to lifers, before 1993, a lifer is placed on parole only for a period of 3 years and not for his natural life. That was then amended at the end of the day with regards to, in an amendment act to being on parole for life. However, in terms of the principle that was established by the Constitutional Court in PARTLA, one has not to look at the date of sentencing anymore, but date of commissioning of the crime, which this bill is addressing. So everything flowing from that means that simply in the application of the act, it will have a, sorry about that. In the application of the act, it will have a situation where, sorry, Mr. Chair, I'm just putting off myself. With regards to the application then of the act, and also with this proposed amendment bill, it will not change the issue as to how it has been dealt with previously. Our policies are making provision for using the earliest date. It's always been applied like that. The only difference now with PARTLA judgment, and it is contained in the bill we submit, is that we have to have regard to the date of commissioning of the crime to establish which parole regime must be applied. In other words, by virtue of an example, the new parole system or parole regime came into being with the Amendment Act of 2011, which, with regards to the new act promulgated of 1998, which came into effect on the 1st of October 2004. With regards to the new act, a lifer has to serve a minimum detention period of 25 years before becoming eligible for parole. Now, before the bill, in other words, as the act currently stands, before the amendment, one has to have regard to the date of sentencing. If the date of sentencing was before 1 October 2004, one has to simply look at the old parole regime, so to speak. The old parole regime with regards to lifers determines that a lifer must serve 20 years incarceration before becoming eligible for consideration for placement on parole. So this means, in terms of the current act as it stands, we must use the date of sentencing to establish. So if somebody was sentenced before 1 October 2004, then they would fall under the old regime and they would have to serve 20 years. That's now lifers. Have to serve 20 years before becoming eligible for placement on parole or consideration for placement on parole. If one was then sentenced after 1 October 2004, then one has to use the new parole regime, which is 25 years for lifers. Now, what PARTLA did, or what the PARTLA judgment then changed, and this is what we have addressed in the bill it's submitted, is that one has to now have regard to the date of commissioning of the crime. So the date of commissioning of the crime will determine whether the old parole regime or the new parole regime will be applicable. With regards to multiple offences committed for which one has been convicted and sentenced, as well as continuing offences, the same principle has always been applied. That is a different principle, and yes, it was also highlighted in a dissenting judgment by Justice Froneman. However, it has always been applied, and it was not part of the gist of the application or the judgment itself, because it's always been applied. But in saying that, we want to make it also quite clear as well that we are in the process of reviewing the entire Correctional Services Act and its regulations. And one of the issues that we are addressing and that we envisage will form part of the regulations is the procedures and processes with regards to parole. That issue is receiving urgent attention, together with issues related to JICs and GBV issues. Now, the envisaged changes to the Act and the regulations is to provide in the regulations for the full processes which currently are contained in departmental policies, but to insert them into regulations. And we will also, and that is why I say it's a very good point that the Foundation is making, that we will definitely include, as a matter of legal certainty, however, although it's already being applied, that when one is working with continuing and multiple offences, that yes, indeed, the earliest date must be utilised, because it will be then in accordance with Section 35(3)(n) of the Constitution. So I hope that addresses the issue raised or the concern raised. We do submit, however, that it's not necessary to place it into this amendment bill, as this amendment bill seeks to amend the Act and thereby the law, so that when one determines the parole regime that must be applied for lifers and determinate sentenced offenders, one has to look at the date of commissioning of the crime and not the date of sentencing. The issue with regards to using the earliest date is a procedural issue we submit, not a principal issue, in principle. And in any event, policies and principles and procedures must be in accordance with the Constitution, and it must be it must meet constitutional muster. So we submit it thus that this bill is not, the object of this bill is not to revamp the entire parole. That we are busy with in the review of the Act, and that process, as we've tabled before, is a 3-year process, but giving preference to issues such as parole, that be tabled as quickly as possible. In other words, a whole revamp of the parole system, as well as the procedures in terms of the parole system, which we submit should form part of the regulations. That is our preliminary points for now. Thank you, Mr. Chair, for the opportunity.
Thank you very much. I'm not sure whether the chair of the subcommittee wants to comment on what he has heard.
Thank you, Chair. Not at this stage. Thank you very much. We might speak tomorrow.
Thank you very much. That is the preliminary response from the department. We still expect the department to give us detailed responses that would also encompass the other submission that was made to the committee, of which the person who made the submission elected not to make oral representation to the committee, but we would like the department to address the issues that were ventilated in that submission. That can be, I'm not sure whether you would want to have preliminary responses or you would want to have the final responses tomorrow at the department.
Thank you, Mr. Chair. Before I continue, I just want, I omitted to just mention that I'm representing the department and also the team leader of the DCS CDC of remand detention, Mrs. Cynthia Ramofolo. So she tendered her apologies because she's already engaged in another urgent meeting as well. Okay. With regards to that submission that was made, Chairperson, am I correct in saying it's the submission that was made by Mr. Buthelezi?
Yes. Yes, I think so.
Thank you. In a nutshell, the submission that he made, was that he was suggesting that the law regarding parole should be rewritten by the chiefs of local villages in all official languages and in accordance with the wishes of the relevant king for those areas, and not in terms of a democracy. Further, he also submitted that government must teach all people the law. They must provide them with booklets on the law, and they must acknowledge receipt of such training and booklets. And only after that, people should then be convicted according to the law they were taught. And that the law must be more understandable for all people. This is in brief our understanding of the submission that we received from Mr. Buthelezi.
Mm-hmm.
In response there to the department, I cannot, there's certain areas that the department cannot respond to, which falls under the domain of other departments. In principle, we submit, for example, the Department of Justice. But from a legal point of view, the Constitution of South Africa is supreme. It's the supreme law of the country, and all law and conduct must be in line with that. Now, the Constitution, as we all know, enshrines the right to democracy and an open democracy with regards to in South Africa, and that the legislator is tasked with the duty of enacting legislation. That, I think, is enough said with regards to that. With regards to parole issue, we do not support whatsoever the notion that it must be dealt with by chiefs of local villages, etc., etc. However, what is quite important and what is valuable from the submission is, yes, that it must be more, that the law must be written in more plain language as far as possible, so that people can understand it. He is correct in saying that it should not just be understandable for the courts, judges, advocates, and lawyers, but it should be understood by any person and any citizen in our country. We fully support that. And as far as possible, we know it's not always practical, but as far as possible to when acts are published or enacted, that as far as possible that it be published in all official languages, so that everybody can understand, because everybody cannot understand or grasp the meaning when it's conveyed only in English, for example. So we do support that. However, we feel it's not our domain, to properly respond thereto. There's other departments and arms of government that needs to provide inputs on that. But from Correctional Services, those are our submissions. We submit, your Chairperson, with respect. Thank you so much.
Thank you very much, Mr. Jacques. Any questions from members, comments? I see Honorable Nivot, Jacqueline, your hand is up.
Thank you very much, Chair. And thank you to the department's response. Just to clarify for my understanding, I would like to know that the Phathekile case was brought forward because he was sentenced after the law was passed in 2004. So now, based on your explanation, I just want to clarify for myself. So he according to the amendment, would get now 20 years and not 25 years of serve. He should serve 20 years and not serve 25 years. So I just want to clarify, in the case of specifically Mr. Phathekile, what he should get or what he shouldn't get. Thank you, Chair.
Thank you very much. Honorable Namathemba Maseko Jele.
Thank you, Chair. I only have one question, Chairperson, which talks about, in terms of the age also. The amendment does not address the issue of the age. The age of the 65 years that may be placed on parole after they have served, in fact, they are 25 years, but now, but the prisoners, in fact, it says the prisoners must also, on reaching the age of 65 years, must be placed on parole. And it seems as if this amendment does not cover that. Maybe if the department can also address, clarify us on that issue, Chairperson. I would love them to say something on that one.
Thank you very much. Are these the only questions from the members?
My hand is up, Chair.
Honorable Mofokeng.
Thank you, Chair. And thanks for all the submission and also the response from the department. I just want to check on how many offenders are currently incarcerated, still maybe fall under the category of vague judgment, that we should also get a clarity on that. But also how many offenders are still in the same position as offender that is Mr. Pasha, and that will be able to assist us to understand whether you are still dealing with the matters or they are solved. Thank you.
Thank you very much, Honorable Mofokeng. I see that there are no other hands. Back to you, to Mr. Jacques.
Thank you, Mr. Chair, and thank you very much for the very good questions, insightful questions. If I can address the first one with regards to the Phathekile case, him specifically, he was convicted for a crime committed, or for crimes committed. He was convicted before 1 October 2004. In fact, he was convicted on the 25th of September 2004 for crimes committed before 1 October 2004. However, he was sentenced on the 5th of October 2004. So he was sentenced. So in terms of the current law, before the Phathekile judgment, one has to have regard to the date of sentencing to establish which parole regime should be applied. Because he was then sentenced after the 1st of October 2004, he was then supposed to serve 25 years before becoming eligible for consideration for parole. I must just pause there and just highlight to the committee and to those who made submissions. It's very important to understand. An offender does not, in terms of our current law, and even with regards to the amendment bill that we have tabled, an offender only qualifies to be considered for placement on parole. It's not a qualification or an entitlement to be placed on parole specifically. It is still up to the parole board, who must make a decision for determinate sentenced offenders, and for the Minister of Justice and Correctional Services to take a decision on lifers, whether that offender should be placed on parole or not. So it's only an entitlement to be considered for the first time. And then the Act further provides that if an offender, after consideration, was declined placement on parole, he or she must then be considered by the parole board and or the minister within a period of 24 months. So I'm just highlighting what the Act says and what the law currently says. So it's not an entitlement to be placed on parole. So it's not an automatic right of any kind. It's only a right to be considered for placement on parole for the first time. In other words, after serving 25 years for lifers, that lifer must be considered for placement on parole after serving the 25 years, and that will be the first consideration. Now, coming back to Phathekile, yes, it's 100% correct. He committed, however, his crimes or the offences before 1 October 2004. And therefore, in terms of the Phathekile judgment, what that means is that one does not look at the date of sentencing anymore, which would place him under the new parole regime of 25 years, but in fact takes him back to the old parole regime because he committed the crime after the offences for which he was convicted and sentenced before 1 October 2004. So that means that the date on which he committed the crime the parole regime applicable at that date must then be applied, which is that he has to serve 20 years before becoming eligible on parole. I can maybe just add, Mr. Chair, if you indulge me, with regards to the current status of the consideration for parole of Parla. It has been submitted to the NCCS for the recommendations and is pending consideration by the minister. As he's a lifer, it must be considered by the minister. But it has been submitted to the NCCS. One has just to have regard that because of the Parla judgment, and I'll get to the totals now because there's been also a question as to what are the stats with regards to those so-called Parla category cases. One has to have regard to the total number of those who has to be considered as a result of the Parla judgment. In other words, the parole consideration dates were advanced by the Parla judgment, and also in relation to the Van Wyk judgment, which also advanced the placement or the consideration process of lifers, as well as determinate sentence defenders, also advanced those dates. So all of that, together with the Van Vuuren judgment, relating to those who were sentenced at the time, but now it's commissioning of the crime before 1993. Because all of that will dictate which parole regime needs to be implemented. So one can then surmise from that it has created a backlog, because all of a sudden there was a lot of offenders that need to be considered. And remember, before they can be considered, a profile has to be made for each and every offender, which consists of a lot of reports from social workers, psychologists, educationists. There's a lot of programs that must be attended. Victim-offender dialogue needs to take place. VOM needs to take place. So restorative justice processes in terms of the Clive Derby-Lewis judgment in 2012, where the court said that restorative justice processes must be done and finalized insofar as it is possible. So all of that has to be done, or had to be done for all the offenders. So that is the issue with regards to Parla. So that is the status also with regards to Mr. Parla himself. That yes, it's indeed correct that he has had to serve 20 years now from the date of sentencing before becoming eligible for parole. Maybe I must just also explain that, because it has created some confusion in the public and issues that we have been dealing with since the Parla judgment. One has to have regard and remember that the date of commissioning of the crime only determines the parole regime that must be applied to see what is the minimum detention period which must be served before somebody can be considered for parole. Then, as soon as one has done that step, the second step is then to, for example, if it's a lifer and he committed the offense before 1 October 2004, he then has to serve at least 20 years. Now, what does that mean? He has to serve 20 years of his sentence. So in other words, one starts to calculate from the date of sentence, 20 years, and 20 years after the date of his sentence. So in other words, if one can look at the example of Mr. Parla, one has then to have regard, he was sentenced on the 5th of October 2004, which means he became eligible for consideration for placement on parole 20 years later, which is 5 October 2024. But in relation to the Van Wyk judgment, the Van Wyk judgment, in essence, what it said is full credits in terms of the old act. Remember, the new act does not talk about credits that can be subtracted from the minimum detention period. Only the old act does. Van Vuuren relates to that. And in that case, the court ordered that offenders must be provided full credits together with any remissions that were granted by the president. So what this means is currently, and in terms of, and with regards to Mr. Parla, the full credits, if one deducts that, it will then be deducted from the 20 years he had to serve, and which will then amount to or be equal to, or the result would then be 13 years and 4 months, or in 8 months, sorry, and 10 months, 13 years and 10 months after credits are deducted. And then he would have qualified, or he qualified for 2 remissions, the remission of 2005 and the remission of the special remission of 2012, which were 6 months each. So that in effect means that he qualified to be considered for placement on parole for the first time in terms of now the Phathekile judgment, working on the date of commissioning of the crime. And then in that we are using the old act, and then the Van Wyk judgment is also connected therewith. He would then have qualified after serving 12 years and 10 months, which means he's already qualified to be considered. Hence, since the Phathekile judgment, he had then to be considered, or the consideration process had to start, which means the profile had to be set up for him. He had to undergo all the necessary programs, VOD, VOM, and all of that, and that is why his profile then was submitted last year to the NCCS, the National Council for Correctional Services, who must then make a recommendation to the Minister for a decision to be made. So I hope I've addressed the issue of Phathekile himself and how this affected him, because one does not just look at the Phathekile judgment, but the Van Vuuren judgment and the Van Wyk judgment, and especially the Van Wyk judgment is also applicable here. I do not, however, currently have the stats with regards to the Van Wyk judgments, but I do have the stats with regards to the so-called Phathekile category cases. And if you indulge me, Mr. Chair, I'm just quickly going to highlight that, because it's also one of the questions. And then I'll address the issue of the age of 65, if that's fine. With regards to the so-called Phathekile cases, those who fall under lifers, the category of lifers, in terms of the Phathekile judgment. In other words, now it's people, it's offenders whose minimum detention periods have been advanced, so which means the parole consideration dates have been advanced. Is a total of who will benefit to be considered in terms of Phathekile judgment is 1,690 lifers, of which 653 lifers have already been considered, and which means that the department is still left with 802 lifers that need to be considered by the Minister in terms of the Phathekile judgment. With regards to determinate cases offenders, or those offenders who are sentenced to determinate sentences, a total of 885 are to benefit from the Phathekile judgment in terms of the consideration dates being advanced. 885, of which 341 offenders have been considered, and then the remaining are still to be considered in that respect. So it gives us a percentage of those who have already been considered at 79.49% for determinate sentenced offenders, and for lifers we are at 44.88%, simply because the process is quite longer. Determinate sentenced offenders process ends with the parole board, the respective parole boards at management areas, whereas lifers consideration process only ends up at the Minister after it has gone through the parole boards for recommendations, and then to the NCCS for further recommendation, and then to the Minister for consideration and decision. Now, with regards to the second question, which I'm addressing last, the age of 65, we are, in terms of the current Act 111 of 1998, one has to have regard to section 73(6)(b)(6), numeral 6, which basically states that any term of incarceration, excluding persons declared dangerous criminals in terms of section 286A of the CPA, the Criminal Procedure Act, may be placed on day parole or parole on reaching the age of 65 years, provided that he or she has served at least 15 years of such sentence. Now, what does this say? In terms of the current Act, and in terms of the principle that has been amended through the Phathekile judgment of looking at or having regard to the date of commissioning of the crime and not date of sentence, it just simply means that those offenders who committed the offences they have been convicted of and sentenced for before 1 October 2004 will be dealt with in terms of the old Act. Those offenders who have reached 65 years and who have at least served 15 years. For those offenders, lifers and determinate sentenced offenders who commissioned their crimes after 1 October or committed their crimes after 1 October 2004, will the current parole regime or the new parole regime in terms of the current Act, 111 of 98, is applicable, and this subsection I've just read will then be applicable to them. So we submit, Mr. Chair, that it is not necessary to include it in the bill, as that is not part of what is deemed to be amended. We have already inserted in section 73, which is the current Acts section, as well as section 130, the applicable subsections in section 136, 1 and 3 of the current Act, which is the transitional measures, referring to those cases where offenders commissioned their crimes before 1 October 2004, but they were sentenced after that date. So in a nutshell, Mr. Chair, to understand Phathekile judgment better, the so-called Phathekile category offenders only refers to those offenders who commissioned their crime or committed their crimes before 1 October 2004, but were only sentenced after that date. It's only to those. Those offenders who committed their crimes or offences before 1 October 2004 and who was also sentenced before that date, by implication means that they fall under the parole regime in terms of the old Act, Act 8 of 1959, Correctional Services Act. And then obviously those who committed their crimes and offences after 1 October 2004 and were sentenced subsequent to that, obviously also after that date, resort totally under the current new parole regime as established by Act 111 of 1998, which is the current Act we are in. So it's our submission that it's already fully catered for with regards to those who have reached, those offenders who have reached the age of 65 in the new Act as well as in the old Act. Simply what Phathekile just did was one has to have regard to the date of commissioning of the offence and not the date of sentence to establish which parole regime. But the principles in each regime of the old and the new regime is unchanged, and it's not what the Constitutional Court ordered. The Constitutional Court did not order a change in the parole regimes, only which date must be utilized to establish what is the minimum detention period which must be served before an offender becomes eligible for placement on parole for the first time. That was a mouthful, Mr. Chair, but I hope I've addressed all the questions. Thank you so much for the opportunity.
Thank you very much. Helen Suzman Foundation would like to make brief remarks. Ms. Kruyer.
Thank you, Chairperson, for the opportunity to respond. And thank you to the department for those preliminary views. I would like yet again, on behalf of the Helen Suzman Foundation, to recognize that the proposed amendment to Section 136 does indeed comply with the order of the Constitutional Court in Phathekile, primarily which required the operative date for the purposes of determining the parole regime to be changed from the date of sentence to the date of commission. And I also appreciate that the department recognizes the importance of using the earliest date in connection with the commission of multiple and continuing offences. However, with respect, I must dispute that the earliest date in these types of cases has always been used or is already being applied. As is very clear from the Constitutional Court's judgment and from the department's own summation of the facts, prior to the amendment coming into force, the date of sentence was used. And of course, that really clarified things in cases of continuing and multiple crimes, where even if an offender had committed different crimes on different dates, the date of sentence is a single date which can easily be picked out. However, now, in line with the changes that are being made as required by the Constitutional Court, if we're going to use the date of commission, it does introduce some confusion in these types of cases. And it's for that reason that the Helen Suzman Foundation proposes that some attempt be made to clarify what the date of commission is in cases of continuing and multiple crimes, so that courts will be able to easily apply the amended act if it's passed. Thank you for the opportunity to respond. That concludes my response.
Thank you very much, Ms. Kruyer. Honorable Xola.
Chairperson, this is just a comment from me to the department that seeing that there's still a lot of work to be done when it comes to this, the work of making sure that this we combine or we deal with the issue of the old and the new regime. I think my comment would be, Chairperson, we after this bill, I would propose that the department must start beginning to look into those issues so that we are able to have one thing. We don't have the old and the new, because that, I think it shows that there's still a lot of work to be done. It was just a comment from my side, Chair. Thank you.
Thank you very much, Honorable Xola. So members, these were preliminary reports. In fact, there were preliminary responses from the department and preliminary interactions from the members. I do think that the department might need to come back tomorrow to possibly respond to the issue that the Helen Suzman Foundation is raising, their final responses tomorrow on the possible confusion that might arise as a result of the multiple offenses. Maybe they might just want to think over it overnight, and we proceed tomorrow. But I think that tomorrow we would not be able to spend a lot of time on the responses, because the department has really responded in depth into most of the issues raised, and I think the points of differences are very, very minor. Can I suggest that after the responses of the department, which I think would not be long, we can start with the deliberation of the bill tomorrow, and then so that we have the date of the 23rd of February as the target date by which we think that the bill must be before the House, so that we allow the NCOP space to also embark on its own processes, because we have a deadline of May, that the bill by that time must have been passed by both houses and accented to by the President to meet the Constitutional Court deadline. So we are working around the clock to ensure that we meet that particular deadline without compromising quality as in the way we interact with the bill. But we must also bear in mind, members, that the read-in provision that has been provided by the Concord, which is guiding us, will lapse in May. And there is going to be a big gap in the law, and that must be avoided at all costs. So I suggest that tomorrow we will start with the responses. If the department wants to make any further responses, especially to the Helen Suzman Foundation, and then we start with the deliberations, and possibly we will discuss the date by when we would be able to meet and just vote on the bill, so that by the 23rd of February, the bill goes to the National Assembly for consideration and possibly approval. Is that in order, members?
Chairperson, I think it's in order, but I will request that tomorrow they can also finish us with the stats for the Van Wyk judgment, please. Thank you.
Thank you. I think that is in order. Any closing remarks on this matter, Deputy Minister?
No, thank you very much, Chairperson and the honorable members. No, we don't have anything else to say except to say that we'll engage with the department further on these morning's deliberations, and then tomorrow we should be in a position to indicate where exactly we stand and how we recommend the portfolio committee must deal with the issues before it. Thank you very much, Chair. Of course, we need to ensure that to expedite the amendments that are envisaged to the entire Correctional Services Act, so that people don't continue to raise issues of concern to them when you are dealing with this matter, which issues are not necessarily related to what we are about in this amendment bill. Thank you, Chairperson.
Thank you very much, Deputy Minister, for the remarks. Members, as we agreed earlier on, I think the department is excused so that they can continue with the other issues, the other work that they're supposed to do. I would ask members to remain behind so that we can deal with the issue of the minutes.
Thank you, Mr. Chair.
Thank you very much.
Have a nice day.
Thank you very much, Mr. Jacques and your team.
Thank you, sir.
Thank you, Chairperson.
Thank you very much, Helen Suzman Foundation, Ms. Catherine.
Thank you, Chairperson.
Thank you very much. Can we have a 5 minutes break so that the committee secretariat can be able to fly to the minutes of the previous meeting? Can we come back at 27 minutes past 10? Thank you.
Thank you, Chair.
Can we resume our meeting? Let's deal with the minutes of the 26th of January 2021. Are there any corrections on page 1? Bonan, yeah. Are there any corrections on page 1? On page 2? On page 3? On page 4?
Chairperson.
Honorable Horn?
Yeah, it's just technical in nature, but I think we should rather say consideration of committee program.
Okay. On page, thank you. Page 4, page 5. Can we scroll down? Can we scroll page 5?
Sorry, Mr. Chair, my hand's up, but you're not seeing it.
Oh, Honorable Bredenbach, sorry.
I apologize. Can we go back to the bottom of page 3, please?
Page 3.
Bottom of page 3. No, okay, maybe the next page. Oh, there, no, sorry, bottom of page 3 is correct. Took the committee, there's a repetition there, took the committee.
Okay. Can we correct that?
Yeah.
Thank you very much. Can we go to page 5 if there are no more hands? Is there a mover for the adoption of the minutes as corrected?
I move, Chairperson.
Honorable Mofokeng moves. Is there any seconder?
I second the move, Chairperson.
Seconded by Honorable Jelly. Is there anyone who dissents? None. The minutes are adopted. Let's look at the matters arising. Let's go to page 1. I doubt that there can be any minute arising out of that. Page 2. Honorable members, I think on point 2, consideration of the committee program, we have tried to correct the program as it was raised by honorable members, trying to at least bring back the Fridays meetings. What is left is for us to interact with the chair of the subcommittee, and I would ask that after this meeting, the chair of the subcommittee and the secretariat and the research unit leave behind so that we can generally go through the items that needs to be discussed, because we wanted to have that political consultation with the chair of the subcommittee, just to look at whether the proposed items meet what we agreed on at Stellenbosch, the program of action of the subcommittee. So I would ask that the chair of the subcommittee and the secretariat and the research unit stay behind. So I propose that tomorrow, after we are done with the processing of the legislation, maybe we can look at the program to check whether the program meets the expectations of the members and the concerns that were raised by the members. We also had to rework the program because we received two dates from the Chief Justice that they are prepared to meet us. So we're proposing the date of the 26th of February. It's one of the issues that we would discuss when we deal with the program. The meeting will be virtual. I suspect that the Chief Justice will also bring the heads of courts, and they would appeal to members that whichever date we agree on, let's try to be all present so that we can interact with the judiciary. So that is the issue that I would like to raise on the issue of the program. I'm not sure whether other members would like to raise any issue around the issue of the program. I don't see any hands, so are we all fine with how we've approached the program, that we will discuss the program tomorrow?
Yes, thank you.
Thank you very much. That was on number 2. On number 3, I think on number 3, the committee secretariat has distributed the list, in fact, the CVs of all the applicants and the summarized version of all the CVs to the members. Can we get confirmation that all members have received the CVs and the summarized versions thereof?
We have, thank you.
Thank you very
We
much.
have received.
Thank you very much. So any issue that members would like to raise on this issue?
Chairperson. Yes, and I think with me, I have only one concern. I think we need to also give an accommodation for those who'd love to have only summarized version. It should not be distinct. I just felt that my gadgets are too much bombarded with a lot of information that I felt like if I would have got only summary, I was going to be fine. I don't know if maybe can in future separate, at least give an opportunity to those who want the whole CV and those who would want to have a summarized one. Thank you.
I think it will be up to the individual member to interact with the secretariat that they would not want to receive the whole information. But I think the secretariat, they were just implementing the decision of the committee. So I think members who would be happy with just summaries would indicate to the secretariat. Are we happy with that, members?
Thank you. Yes, thank you, Chair.
Thank you very much. On point number 4, members' comments and questions. Can we go there? Bonani, can you go there? Are there any issues that members would want to raise as matters arising on point 4? Committee Secretariat, how far are we with the issue that was raised by Honorable Horn, which we said we need a legal opinion as to how do we process the issue of the deputy chair, whether how do we consider those who are currently serving as commissioners, because it has never happened before, but we thought that the issue raised was valid, that it needs consideration by ourselves, and we would need a parliamentary legal opinion.
Chairperson, can I respond to this issue tomorrow? I've been trying to confer with Sia, but it's not available on his phone. So okay. I can provide a clear answer tomorrow.
Okay. Any other issue on point 4, members? On point 5, presentation by the Department of Justice. That was, I think this one it was on state liability. I think we did process we did refer the bill back to the department. So we need to update our processes and to also inform the programming committee so that it does not appear continuously on the programming committee that the bill is still with the committee. So I think it will be important that we communicate with the programming committee that the bill is now back to the executive. The executive is dealing with it. It's no more before the committee. Can we do that, Secretariat? Okay. So are we all happy with the matters arising that we have raised everything under matters arising? Members?
Yes, thank you.
Thank you very much. I think the other issue that we just forgot to put on the agenda, it's correspondence. I know it will not be fair to ambush members with the correspondence that they have not seen. So we will circulate today correspondence from the Minister of Justice and Correctional Services. The Minister is requesting an extension to the investigation that we said he must conduct on the comments that were made by the chairperson of the audit committee. We had given the minister up to the 31st of January. By the set date, he came back to me to say that he would ask for an extension. I know that members would not be in a position to discuss it now because they've not seen the correspondence. So the correspondence will be circulated so that maybe tomorrow we can discuss that issue, members having had sight of the correspondence. Is that in order, members?
Yes.
In order, Mr. Chair, I must say it's a little bit worrying that on the due date he asks for an extension. But anyway, let's have a look at it and we can talk about it tomorrow.
Okay. So let's do that, honorable members. Thank you very much, Honorable Breitenbach. I think that would bring us to the end of the meeting, and I request that the Secretariat and the chair of the subcommittee to remain behind for a few minutes so that we can just go through the program and look at the items that are being proposed for to be discussed by the subcommittee.
Thank you, Chairperson.
Thank you very
Thank
much.
you.
Thank you.
Thank you, Chair.
Thank you very much. So members who want to be excused, they can be excused. Anybody who wants to be excused can be excused. It's just a meeting between us, the chair.